Me tonight. I teach a class at UCSD on NEPA as well. That is a 9-week class. So, presenting to your group, I wanted to first of all kind of put things in a little bit more programmatic level about NEPA, and then focus on some areas that you'll be more focused on from a cultural standpoint. And so I'll highlight that towards the middle to the end. And if there's some questions, I mean, this is a small group. So if there's some questions, feel free to stop me or cue from a standpoint of putting some comments in to cue Rachel so she can stop me. But there's probably a varying degree of understanding related to NEPA. So I wanted to start off with from the very beginning and then go into a little bit more detail so that it accommodates a varied level of understanding. So there's, different contexts to NEPA, but it was established in 1969. And it came about because of all the development within the Industrial Revolution. Let's see if I can go to the next slide. Did that cue to the next slide, Rachel?
It's still on slide 1.
Let's see. Sorry about that.
There you go.
So going back, it came about because of the development of the Industrial Revolution and the fact that there wasn't really a platform for citizens to be involved and to have a understanding of these projects so that they were made aware and had a voice in the overall process. And there were concerned citizens that found out that there was degradation happening with the environment, and the fact that there wasn't a policy or a rule or a regulation related to the human environment. And the human environment is something specific to NEPA. And I'll go into a little bit more context, but those of you who work in a CEQA world as well, CEQA is more related to the natural environment. And although there's some elements regarding the resources that are the same, that this human environment versus the natural environment is really one of the big elements that's different related to NEPA. And it's really defining from a interdisciplinary framework for federal planning. And then although there's a Council for Environmental Quality that is the overarching guidelines, all these different federal agencies kind of tier their compliance from the CEQ. And you'll hear me reference CEQ throughout the presentation. And they're kind of the formulaic element that defines what is going to be the guidelines under NEPA. And then all the individual federal agencies have a little bit different specific set of procedures that is specific to their agency. And so I'll be talking about the different types of environmental documents, such as an EIS, if you've heard of an EIS, and environmental assessments in EA, which is a mid-level document, all the way down to categorical exclusions, and introduce the framework in the documentation that specifically goes over the different levels of defensibility for NEPA. And with all these regulations, there's really a need to have a watchdog that establishes these actions, and then the reaction to ensure that federal agencies comply with these federal requirements. So after a lot of thought and overall process with the environmental movement, that was intended to take a holistic look at preserving the environment as it relates to other industrial development projects. And so the concept of the EIS, the environmental impact statement, was all defined based upon some important individuals. And let's see. Might have went too fast here. Yeah, so the individuals that I'm referring to, there was a Professor Linton Caldwell, and he was really provided with a role in Congress and the president and the overall community on watch on how to document the role and what needs to take place, and how potential conflict at a state level was put into a federal role of responsibility. So he was really one of the founding fathers. And then there was also a legislative action that this was authored from Senator Henry Jackson, and he was from Washington State, where there were at that time, there was a lot of forestry activity and clear cutting was going on. And he put a protection and put many prosecuting attorneys on his team and watching what was going to happen and how the community and the environment was being protected. And then he won a seat in the House of Representatives, so that gave him an official role. And his mission and goal was really a leading voice in energy and overall environmental issues, in balancing the use of preservation with the use of natural resources. And then there was a Congressman, John Dingell, and he was really a mover and shaker, and he was an author of NEPA and assisted with the Clean Water Act in 1972. He was involved in the Endangered Species Act and the International Wildlife Refuge movement throughout the US. And then President Nixon was really the individual that signed NEPA into law and stood behind the purpose of having an element of defensibility and having a component to elevate the environmental impacts and counterbalancing that with the environment and the associated development opportunities that were going on at that time. So overall, these were the people that were involved early on in the architecture of NEPA. And I just think that's important because the structure and how things were put together is important with the overall implementation of NEPA. Then the NEPA objectives. There's a federal compliance that provides agencies with supplemental legal authority that they're in charge of implementing as it relates to the environmental issues. So specifically, there's a defined process, there's templates, there's expectations and overall disclosure to the public to make sure that there's an element of transparency and overall compliance. So no one, in essence, is under this cone of silence. Rather, it's very public and has an opportunity, and so that the opportunity for them to review and weigh in and question as to what these proposed actions are is really the transparency element of NEPA. And because of these objectives, there's a mechanism to resolve some of these environmental issues. And because of a intergovernmental communication, they're not siloed, meaning they have to all work together to make sure that there's consistency. And so this really creates a dialogue and a focus on public participation, and then a disclosure to provide any additional information that is needs to be detailed and frankly, just considered when it comes to the NEPA process. And so there's a lot of federal agencies and they all act as trustees for now and the future. So for example, there's often preservation, meaning something is preserved for the future, mitigation and ongoing requirements to protect the environment for the future. So it's not only important to consider the initial impact related to whatever the proposed action is of that direct effect, but it's also the indirect and the future consequences of the proposed action. So the disclosure and then the overall benefited use is also defined and further evaluated. And there's a balancing act to maintain both the human and the natural environment to make sure that they're considered to maintain the diverse environment that is part of the preservation of NEPA. So consider the current and future generations so that there's disclosure of what the consequences of that proposed action is. So now you're asking yourself, well, why do I have to comply with NEPA and why is it necessary? So basically, here's all the things that weren't happening before that really were promoted the need of why we have NEPA now. And it's really environmental factors were rarely considered. There was little public notification about projects. Projects would just come up, be built and implemented without really getting weigh in from the public. And then public comments fell on deaf ears. If somebody commented or spoke to their local legislative or agency, it might not go anywhere. And there was no interagency coordination. So all these different federal agencies and state agencies weren't necessarily talking to each other. And so these decisions were made basically behind closed doors without any sort of explanation. And then there was really a limited opportunity from a judicial standpoint to have any sort of enforcement because it was already too late. That the projects were already being built before anybody else was stepping in to kind of question the action. So how is NEPA different from other environmental laws? Well, there's a lot of, you've gotten a little taste already that there's really a lot of dimensions to NEPA. And federal agencies really need to coordinate so that they have a lead agency, meaning that lead agency takes the lead role in defining and administering the action of NEPA. And then there's all these different coordinating or cooperating agencies that have other roles that cover areas such as permitting, if there's collaboration that needs to take place, reviews, et cetera, that there's various elements where these cooperating agencies get involved. And so overall, the analysis is evaluated based upon the proposed action as a whole, and not just looking at in your case, a cultural or a biological environment, but the whole environment collectively. And it's really necessary to evaluate other agencies' compliance, such as U.S. Fish and Wildlife Service. If your lead agency is a lead agency such as BLM, Bureau of Land Management, FHWA, Federal Highway Administration, that there are specific procedures for all these different federal agencies. So it's really necessary to make sure that you have full integration of the federal laws as a whole. So specific to FHWA, Federal Highways, I work in transportation primarily, and I work with FHWA a lot. So I used one of their flow charts here because I think it really sets the stage for an overall perspective and initiating the steps from a planning, from the initial steps with identifying the purpose and need on a more sequential basis. So there's really, NEPA is highly procedural. And so starting with, for the proposed action, what is the project? And then looking at the purpose and need of the project, and then identifying the stakeholders. Who do I need to reach out to and make sure that they're part of the early onset of the project? Because if they have a certain opinion or direction that they want the proposed action or the project to go, that they're involved in that decision making. And then who's doing what? This is probably one of the most important things, because in order to keep your proposed action and project moving forward, you have to know what everybody is doing and understand what the totality of the results are. And then there's a disclosure of if there's any sort of adverse effects of the proposed action. So on the other side, you can see from let's see if I can put my cursor, from an agency stakeholder and public input, that this process is fluid throughout the whole entire process. And that's really important because there's different community, there's different stakeholders that need to be involved at all steps of the project. And so overall, I think it's just really important to make sure that the linkage of the process and what needs to take place when is defined early on. And so the key participants of the NEPA process, you have the overall agencies, and you heard me mention CEQ, Council for Environmental Quality. They're kind of the initial procedure and guidance that is defined for NEPA. And then EPA is the overall agency that gets involved from a final review, from a federal posting. And then you have your lead agencies, and this could be from, as I mentioned earlier, from a BLM, Bureau of Reclamation. You might have FHWA, FTA, Federal Transit Authority, Federal Railroads. And so depending on who the lead agency is, really depends on what the next steps are for guidance. And then you could have, you know, what I do and what Rachel does as a third-party contractor or consultant carry out these processes under the umbrella of who the federal agency is. And then you may have some private project applicants if you receive federal funding and you're on federal land. Those are queues or nexuses that require or trigger the NEPA process. And then, of course, you have concerned citizens and organizations that get involved, and they too are participants along the NEPA process. And then you heard me mention cooperating agencies. And so these are agencies that you may need a permit from. We work with U.S. Army Corps of Engineers and do permitting for impacts to wetland habitat and waters of the U.S. And they typically will get involved and be a cooperating agency because we need something later on down the road in the form of permit from them. And then Native American tribes, you know, there's a consideration in a cooperating agency agreement, even more emphatically, depending on the designation of the tribe. And then there's also state and local agencies that can also be cooperating agencies, depending on what you need and when. And then overall, as I mentioned, EPA, and I think it's important to define what their role is. And they have the review. So they review the environmental documents during the public review. And to determine overall adequacy and acceptability of the environmental document. And then they're involved from a filing and noticing perspective, that they provide noticing for the federal agencies and the stakeholders and the public so that they can provide comments, and then they post to the federal registry. From a cooperating agency perspective, they participate directly with the federal leads for NEPA and process all of their regulatory programs, such as EPA's Clean Water Act, to make sure that there's full compliance. So just because I know I've whet your appetite for EPA and the NEPA process as a whole, I wanted to provide, this is a little bit more of a comprehensive slide that does provide a link to EPA's website. And within, they do a really great job at, it's almost a flurry of maybe too much information at certain points, because there's a overall explanation of what EPA's role is. And then they have environmental documents that you can review. And this is also a clearinghouse that you can access those documents. And then there's information on the federal agencies that must file from a EIS, which is a environmental impact statement. Any comments that have been received, there's actually a rating system of EISs and proposed federal actions. And there's just lots of statistical information, like how long it takes to process documents and things like that, if that's of interest. And then a list of federal agency websites. So if you're working with a specific federal agency, you can use this site to get a little bit more detail and get access to procedurally what are required for these individual federal agencies. And then if there's updates and changes, and NEPA has not changed that much over the years, but there are some updates periodically, and this is an area where you can access that information as well. Now, I also want to talk. And then successfully integrating NEPA with other environmental laws and requirements. This is something that I wanted to go into a little bit more detail with this group, to get into the cultural details and how NEPA has a role or an arm in that. And so the overall goals of the NEPA regulation, in short, is really just avoiding duplication and reducing the delay of the proposed action. So the requirements are maybe similar, but the implementation, depending on who your federal lead agency is, may be different. And let's see. And so here's an overall. Let's see if I can get to here. Here's an overall umbrella of some of the regulations that are under NEPA, and as you can see, it's really extensive. And I thought it was important to see all the administrative elements under NEPA. But specifically, I want to go into the Section 106 of the National Historic Preservation Act. And overall, why integrate the from a NEPA standpoint? And it's really to have the transparency, to try to funnel information about the proposed action in one environmental document. So that way you have a single document that you can refer to And agencies have a sense of disclosure and collectively what information is part of the proposed action, because otherwise you'd have all these separate environmental documents, and the amount of paperwork and overall understanding what the impacts and adverse impacts of the project or proposed action would be almost impossible to track. So it's really about having that consistency, and then there's almost forced collaboration because you're working in one document, and you have your, remember, your lead agency and then all the cooperating agencies. And then from a NEPA integration, the lead agencies are really encouraged to prepare joint documents with the state. And that's many of the documents that I work on have to be compliant with CEQA and NEPA. And so CEQA is the state, California Environmental Quality Act. And then integrating if you're preparing an EIS with other environmental reviews, and then overall consultation requirements, make sure that happens to the fullest extent. And in EIS, there's a whole list of federal permits and licenses that are required. So it's really important to have that as a one-stop shop, so you know from a entirety of what's going to be required from a not only environmental document, but if there's other permits that are required, that is all defined within the environmental document. And then the integration applies also. There's the mid-level document, which is a environmental assessment that leads to a finding of no significant impacts. So that's still a requirement, no matter if it's a mid-level document of an EA all the way to an EIS. And then some major environmental compliance on a federal side. This is just a little bit more of a clearinghouse as well. But I want to focus on the Section 106 information and try to go into a little bit more detail about that specifically. So there's also a whoops. And so there's also the states. Not every state, like California, has their own environmental regulations, and California is a little bit unique, but there's other compliance that states have that, for example, Washington State has a SEPA, and the state agencies may get delegated from the Clean Water Act as well. And then there's the air pollution state agencies that are delegated from the Clean Air Act. And then here's the elements related to the affecting the cultural resources. And so you have the Advisory Council on Historical Preservation, and then you have the State Historical Officer. And they have oversight responsibilities related to NEPA, specific for these different acts here, of which you probably all are very familiar with. But I just wanted to put them in a little bit more of a laundry list so you could see the integration with how, from a Section 106 perspective, what needs to be included in the NEPA process. And then overall for Section 106, the federal agencies are required to identify the historical and archaeological properties near the proposed action, including properties listed on the National Register of Historical Properties, or properties that the agency and SHPO agree may be eligible for listing. And sometimes that's a little bit of an evolution if the eligibility needs to be determined. That's a dance that requires the lead agency and then also part of SHPO and the historical properties. And so if the proposed action is determined to have an adverse effect, then it's really the federal agency that they must consult with SHPO and make sure that the Advisory Council on Historical Preservation is also part of the discussion to make sure that the development of the alternatives and any mitigation measures are applied. And that's a really important element to make sure that that coordination takes place. And then the overall proposed action can move forward, and the environmental document will detail all that and support that information so that that is also disclosed. Of course, there's some information within the Section 106 process that doesn't get released to the public, but there's some elements in there that talk about overall compliance. And then the Section 106 process, I thought it would just be, it would be good to go over all the necessary steps from a federal agency that they'll need to consult with SHPO regarding the proposed project and make sure that there's the definition of what effect the proposed project is going to have on the properties listed or that are eligible to be listed. And so it's really the integration of a five-step process, or six-step process actually. And it's about identifying and evaluating these historic properties and then reviewing all the information. So you have your area of potential effect, you have your notify any concerned or interested Native American persons or groups. And then you go through and you do your record search, you conduct a survey, developing the recommendations that if there's additional surveys or a preservation that needs to be put in place. And then sometimes, depending on what those findings are related to the proposed alternative and proposed action, that you have to redesign the proposed action because there's going to be impacts to those resources. And then step two, assessing what these effects are. If there's historic properties present that meet eligibility and it's determined that properties will or impacts will fit into these different categories where you have a no effect, you have no adverse effect, or you do have an adverse effect. And then depending on what the outcome of that action is, you go through and start your consultation. So you have possibly memorandum of agreement that needs to be put in place. And then you also move into the council commitment, and that is having the agency submit this memorandum of action or agreement, and then they can either accept that, request changes, and then what typically happens is there's issuance of written comments, and that's a process of making sure that there's an understanding and an agreement that is put in place. And it's not until all those steps take place that you can proceed with your action. And I think that's just really important to make sure it's a step-by-step process. And even though I said that NEPA hasn't changed that much over the years, there are some updates from an advisory council on historic preservation in 1999. This was adopted to allow federal lead agencies to use the NEPA process to comply with the requirements of Section 106 in lieu of preparing a separate environmental assessment or an EIS. And so this happens with many of my projects that require permits from specifically Army Corps of Engineers, and that we end up doing the Section 106 process as part of the overall proposed action. And there's specific steps that you have to put in place, and that is make sure that you identify what consulting parties during the scoping process so that you don't leave any of those entities out. And then you identify the historic properties and assess the effects of the proposed action. And then you consult with SHPO or the tribal historical preservation officer. And then you involve the public as required. And of course, there's certain disclosure of information, and some details are not shared with purposeful intent. And then from that process, you develop the alternatives. If there's mitigation measures that you need to have to avoid, or minimization measures, or if there's a specific mitigation for adverse effects. And so the overall results are really about harmonizing Section 106 with NEPA to reduce the amount of duplication that can result in delay. And so that's something that is good to note, that the Section 106 process can be integrated into the overall NEPA process. And then from a federal and intergovernmental collaboration, I think I wanted to just talk about a few additional steps in identifying and developing and sharing better communication for the public to make sure that there is that collaboration from a tribal, state, and then local partners. And typically there's guidance, including sample agreements and templates, so you can have that information, and then that becomes a better, more advanced collaboration with your partners. Meaning if other people have done that before, then you can kind of use their templates and make sure that you're not missing any steps. And then sharing the lessons learned, and they're not always success stories, and so it's really about the coordination through CEQ, the Council of Environmental Quality, and having meetings and workshops and training. So you're refining these steps to make sure that it's improving over time. And then developing training using traditional and maybe non-classroom type of methods, which we're all pretty good at these days, for enhancing public involvement. Going out and doing public meetings is really not something we've been doing for the last couple of years. And we've shown that there's different ways of getting information out there that is more effective at reaching more people, and making sure that we use those methods so that we eliminate the barriers to successful coordination and collaboration. And then developing a citizen's guide to NEPA so that other people and entities understand what the basics are, and dispel misinterpretations and provide helpful tips about how to participate in the overall NEPA process. Oh. So I think my question slide didn't quite make it, but I know that's a full throttle digestion on a Tuesday evening. But I did want to put it out there if there's some questions, and I can provide some more resources to the group as well. It looks like we do have a question in the chat.
Do you want me to read it aloud for you?
Yeah.
Okay, so it says, so what I'm getting to reduce delay and share with public as required by law purposely. Am I right to think that this is to advance the process and not necessarily to protect the identified potentially significant resources? How does this process work if a state governor wants to push forward a project?
Well, you always have kind of conflicting priorities, and the NEPA process tries to have a sense of disclosure. There's a compliance issue as well, and even though that there's federal initiatives and even state issues, as this person has indicated, there's still a compliance that needs to take place. And specifically with cultural resources, there needs to be an evaluation that there's no other alternative that can be proposed to avoid cultural resources needs to be strongly considered. And cost and priorities from other entities are not the governing factors, although I think there's always influence on what the outcomes are going to be. But NEPA is very much procedural and has requirements that must be implemented in order for projects to get approved. And I think that has a lot to do with why the environmental process can take so long, because it's really about trying to get that definition of there's not any other unavoidable alternatives that should be considered to make sure that you're not impacting these resources. I don't know if that helps to address the question.
There was a follow-up question to that one. So it's saying, is there any teeth in NEPA? Like, what happens if recommendations are not addressed? I guess if there's any kind of like punishment for not following NEPA.
Well, there's fines if projects move forward and impact resources. The environmental phase of projects is typically where there's legal implications, and if the environmental document is not adequate, it can get sued, and it can go all the way up to an executive order with the courts to make sure that these the information is accurate, meaning all the analysis and environmental consequences are defined within the environmental document. And if it's not, then the project will get sued and get delayed and won't be able to be built. So I didn't really get into too much of the legal precedent of NEPA, but it's really important to make sure, depending on what your interests or concerns are, that you look at the case law. And the case law since 1969, when NEPA was enacted, has really driven the direction of NEPA. And although the law has not changed, the act has not changed that much over time, the legal precedence is something that is getting redefined, and that really becomes the defensibility of some of these projects in environmental documents. Punitive damages, absolutely. I think entities get fines throughout their process. It happens more on probably on a water quality, from permits, from not applying the mitigation measures, not carrying out the actions and environmental commitments record that was defined within the environmental document, that there's fines and damages that the proposed action or lead agency gets thrown at them.
Another question came in. It said, for projects such as a long linear project with multiple federal agencies as landowners, is there a requirement for them to produce a joint document, or is it just a recommendation? Is it your experience that joint documents happen more often than not?
That's a great question. So that I mentioned the defining the lead agency, because you can only have one lead agency. And so even though you may have different landowners from a federal and probably a state standpoint, that they need to come together, and sometimes this has to be done through legal action, that there can only be one lead agency. And then those other agencies that can be federal or state agencies become cooperating agencies. And with that, you get the integration of all the agencies, meaning they have to talk to each other and have to make decisions based upon the environmental document. And so everybody has a voice, but because of conflicting opinions and somewhat varying degree of guidelines, because remember, CEQ is kind of the overall guidance, but the implementation of each federal agency and the thresholds of what defines an adverse effect may be different. For example, the Bureau of Land Management is going to have a different priority than maybe U.S. Fish and Wildlife Service. And so you have to make sure that you have that dialogue with all the agencies and make sure that your environmental document addresses those. But because of keeping things from a lead agency priority, those guidelines are set forward depending on who the lead agency is. And then let's see, did I answer all that? Experience that the joint document happens more than often than not. The joint documents that I was referring to are typically a CEQA NEPA. So you have a state and a federal. And I'll use an example for a project on the I-15 down here in San Diego, is that is on the interstate system. So FHWA has the lead role on those types of projects on the state highway system. And then if they're crossing the city of San Diego or within the county of San Diego, those agencies may be the state CEQA lead agency. So you can have two different lead agencies from a state standpoint and a different lead agency from a federal standpoint. And those are joint documents that get put together. But you would not have a joint document where you would have two federal agencies as leads. So I think that, and feel free to go into the chat if that doesn't answer everything that you wanted for your questions.
Any other questions? Unmute or put in the chat, either way. Well, thank you so much, Lorraine.
Okay, well, again, thanks for having me. And I know it's a Tuesday night type thing, and maybe this is lulling your children to sleep, or maybe you to sleep at this point, but I appreciate it.
And everyone in the chat is saying thank you so much. I think they're all awake.
Oh, good. All right, thanks again.
Thank you. Have a good evening.
All right, bye.